If you could call the roll.
Dr. Greenberg.
Present.
Rob Capanelli.
Here.
Dr. Kader.
Here.
Dr. Eiler. Gail Falk. Gail Falk.
I am here.
Dr. Gaze.
Here?
Dr. Ireland. Not here. Suzanne Jones.
Yeah.
Dr. King. Stephanie Lawrence.
Here.
Dr. Odeji. Not joined yet. Dawn Soderberg.
Here.
Judy Scott.
Here.
Dr. Tando.
Here.
Dr. Tortolani.
Here.
Scott Tucker.
Here.
Megan Campbell.
Here.
Kurt Keel.
Present.
Justin Shank. Here to speak. Scott Frenia.
I'm here.
Tracy Hayes.
Yep.
David Hurley. Here. And I see you're here and I am here. Is anybody here that I did not call? Thank you.
All right. Do we have any guests? I don't see anybody in the room. Are there any guests online?
I do not believe so.
Do you have any other comment, David? Okay. Hopefully everybody had a moment to look at the minutes from our last meeting. And so I'd entertain a motion to accept those minutes
So moved. Philibert.
and a second.
Second, Chuck Noy.
Any discussion on those minutes? Anybody see anything that needed to be changed or modified? All those in favor of accepting those minutes as stated, say aye.
Aye.
Any opposed? Any abstentions or recusals? Okay, great. Board issues. I just have a brief question for Ron. Do we have a time for our stipulation discussion?
We don't necessarily because you're the one hearing it. So there's no other factors.
No one else is joining us. Okay, thank you. Board issues. I don't have anything specific. We were going to get into some of the legislative stuff. That's where the meat of my issues are going to be. And looking for some consensus from this group. But besides that, I think it will be several of us going down to Baltimore before our next meeting at the end of this month for the national conference, which should be exciting. You know, Rob is going, Gail, you're going, Dave, you're going, David, you're going, and I'm going. So we'll all be down there too. Oh. So we'll have a good time.
Look out.
I'll send an email out to everybody who's attending with everyone's contact information, and I'll set up a group text. I'll send everybody a text so that we can, it's once you get there, it's helpful to be able to make plans for meeting up for meals or whatever.
Some of us might be going in the same plane and take a Uber to Baltimore.
Yeah.
I want to take a bus. Oh, sorry.
What was that?
I want to take a bus.
Take the train.
Or the train.
That's right, you're going to train.
I hope you have a great time. It was
Yeah.
great going to last year.
Yeah. Looking forward to it.
They do a good job.
All right, administrative update, David.
Yeah, so first, we hired a new investigator. Very exciting.
Great.
Took a while. We went through an involved search and interview process, and we hired a gentleman who retired from the Burlington Police Department with over 20 years experience, and his name is Mai Nguyen.
Win.
Spelled Nguyen. Really just a wonderful person, and he spoke to several of his former supervisors, chain of command at Burlington Police Department, and it was hard getting off the phone because they had so many wonderful things to say about him. He had much of his career was focused on investigations, first as a detective and then supervisor of detectives, and he had a very strong record. He was somewhat consistently increasing responsibilities. And so we're excited. Scotty knew him when Scotty was at UVM, and they worked a lot in coordination with Burlington. And so just only other thing on this, I want to say thank you to Kurt and Megan and Scotty and Kelly and Ron and Scott Tucker, who all were involved with reviewing the applications and being parts of the first and second round, or first or second round interviews. And so really happy with the way this came out.
What did you say his first name is?
My M1
And why?
and with yeah, Emma with so yeah, I think you'll all enjoy meeting him. And again, he starts on Monday, so you'll see him all in within the next couple months. Everybody's having in-person committee meeting, so you'll all be able to meet him in person pretty soon. So obviously, the other big issue is the go live of our new system. It happened a week ago, Monday, on the 23rd. We had a soft go live. We at the last minute recruited some of our members who are licensees to be guinea pigs to sign on and help us test the user experience for the licensees. And we got some good feedback from all of you. And I said we couldn't send out the message inviting our 7,000 plus licensees to do it until we had tested it in that way. And so the message went out on Tuesday. And it's been a lot. We had about a 6-week period where we were in what's called user acceptance testing, UAT, where we were going through every aspect of the system. And especially Kelly and Tracy were really knocking themselves out testing. And it's just, try and give you a sense of how much work it was. We have, how many different applications do we have, Tracy?
17,
Just 17?
maybe more. I don't know. I think I blocked it.
Because it's like
A lot.
we have every profession, and then within each profession, there's different types of applications. Many of them, you have pro bono or
25.
and different kinds. And so they have to create had to create applications and then submit them as if they were outside users, and then go through and process them. And you have to test every little bit. So, they had to make sure that they said, yes, I have malpractice. Yes, I've been convicted of a crime. Yes, I've done this. And make sure that every So we flipped the switch on last Monday, and it's been a lot since then too. A lot of little things that you'd never expect, and it's also been a real burden on Tracy and Kelly and Marcy, who's upstairs now, probably taking calls. Our licensees who are running into problems. We had a hiccup with, we found out only after we started getting calls that people contractor had misinterpreted some of the contractual provisions about the data not being able to be stored overseas as prohibiting overseas users. And so they had set it up so nobody from overseas could get in. And so that got fixed. But I think it's going to be really good. And I also just want to publicly thank VMS. They have assisted us with a note in this week's VMS Rounds newsletter. letting all of their members know that they need to do this to go on and register their account and claim their license to go forward in the system. And you all will our plan is to transition at some point over the next months, and hard to say exactly how many months at this point, as we wrap our arms around using the system and find the bandwidth to make sure that we're set up for a smooth transition to give you all access, and we'll all learn to navigate a little bit in the system, and it will be pretty much straightforward. It's going to be, in effect, like HISMWare will just be a document sharing platform where we'll be able to see the documents associated with the case, which is essentially what we do right now. So more to come on that.
We don't have to learn anything new, right?
Oh, not at all.
Have fun.
Easier than getting a new cable box. Also, just wanted to note the in-person committee meetings coming up. We have Central on April 10th, and North on May 14th, and South on May 20th. So for any of you who haven't gotten it yet, Kelly is sending out lunch order requests, or breakfast order requests. If I guess some of them are a little buffet, maybe. We get orders, just orders from everybody. Have orders. Okay.
South is not in person, right?
Okay.
In May.
Maybe it's fine.
Oh, we're in May? Okay, I have it written down at home in June. Okay.
Well, good thing I mentioned it.
I won't be here. No.
And last, impromptu, just it's going to affect staff here. I've been spending time telling you all about the return to office, and you've probably been hearing about it a little bit in the news. And the union filed a labor grievance over the state not bargaining the return to office conditions, and it was announced this morning, the decision came out and the union prevailed. So everything is kind of going on hold for the moment. And
They've appealed, though. The state has appealed. The email just came over.
no direct impact on you all as members, but something that all the staff is really interested in. And we've been having some issues getting appropriate space to do our work with, the privacy that HIPAA and the nature of our work demand. I can't say that it's altogether unwelcome at this point.
We can all hope that sanity will prevail.
Okay, so that's the end of my admin update. And if we want to proceed with
Why don't we do the hearing now, get that over with, if we don't have a specific time that we need to do that. So we have a proposed stipulation consent order on respondent Paul E. Gerard, PAC. It's from the South Committee NPS 013-022 and NPS 204-1023. I'm going to be hearing this. Judge Belcher could not join us today, so I will be performing that duty. And Mr. Keel, I understand you're presenting for the.
That's correct.
Okay. Well, is the respondent present? Are they going to be here or their counsel?
They are not. I spoke with Mr. Gerard's counsel, and he indicated that neither he nor Mr. Gerard.
Is that the case?
Okay. So these cases concern Paul Gerard, who is a physician assistant. He was first licensed to practice in Vermont in 2005, and his license lapsed on January 31st of this year. The board opened these cases after receiving 2 complaints from patients about Mr. Gerard's conduct during exams. The first complaint alleged that Mr. Gerard touched the female patient in an unauthorized and unwanted manner during an exam at the UVM AMC emergency department. And the second patient alleged that Mr. Gerard made inappropriate and insensitive remarks during an exam at a Clear Choice urgent care clinic. The committee's investigation determined that patient one presented to the UVM-MC emergency department after experiencing symptoms she believed to be related to kidney stones. During his exam of the patient, Mr. Gerard palpated her lower stomach near her hip where she was experiencing pain. Patient one complained to UVM-MC after the exam that it was unnecessarily intimate. And after she made her complaint, UVM-MC terminated Mr. Gerard's employment. The investigation further determined that patient two presented to a Clear Choice urgent care clinic after experiencing pelvic pain that she thought was caused by ruptured ovarian cysts. As part of the exam, Mr. Gerard asked the patient questions about her sexual history and that she felt were unprofessional and caused her embarrassment. Mr. Gerard cooperated with the investigation and provided information that was helpful to the investigation. After considering the evidence gathered during the investigation, the committee concluded that Mr. Gerard's conduct violated Title 26, Section 1354A35, which prohibits licensees from engaging in disruptive behavior that could reasonably have been expected to adversely affect the quality of care rendered to a patient. After negotiations, Mr. Gerard agreed to permanently surrender his rights to renew his medical license and agreed that the surrender of his license is final and irrevocable, and he shall not seek licensure reinstatement as a physician assistant in Vermont, regardless of circumstances or passage of time. The stipulation provides, as I just mentioned, that his license is permanently surrendered. The committee determined that given the strengths and weaknesses of the parties' respective cases, that this was a sufficient resolution that protects public health and safety by ensuring that Mr. Gerard does not practice again in the state of Vermont. And given the proposed stipulation consent order, it would be unlikely that he could obtain licensure in another state as well. If anyone has any questions, I'd be happy to address them.
So this case, as it came from the south, is going to be decided by the north and central investigative committees, excluding myself. So if does anybody from either of those committees have any questions?
Question. Was there a chaperone or a nurse present during these exams?
There was in the first exam, there was a scribe and a nurse. And in the second, there was a nurse, although there were times when in the second exam when the nurse would leave and the patient would be alone with Mr. Gerard.
Did they provide testimony?
They provided information, yes. There was an investigation by the Burlington Police Department. There was also an investigation by the Attorney General's Office, Medicaid Fraud and Residential Abuse Unit. And those individuals were interviewed and provided information in those investigations.
Do they have any other questions?
It sounds like reading between the lines, this was more serious than the actual written stipulation. Is that a fair reading of what happened?
I would characterize it as serious. Mr. Gerard would dispute some of the claims. And so in making this decision, the committee considered the strengths and weaknesses of both our case as well as Mr. Gerard's, and the potential of not getting a positive outcome if it went to a hearing. And so I think, yes, by reading through lines, you could gather that it may be, the allegations may be a bit more explicit and I guess serious than are as they're described in the order.
Question, is the penalty consistent with the penalties that have been presented to or agreed to in prior similar cases?
I think that it is in the sense that, you know, he has permanently surrendered his ability to practice in Vermont. That would be the result if we took it to hearing and obtained revocation of his license. It would have the same effect. So in that sense, it is consistent. He is no longer practicing in Vermont and cannot apply for a license in the future.
Peter, I saw your hand up.
Yeah. I was wondering, with this being a physician assistant, does any of the investigation go back to the physician they have a practice agreement with? I understand that these are professional and judgment allegations against him, but is it ever brought back to the MD or DO supervising?
I don't believe that it was in these cases. I know with respect to UVMMC, they did their own investigation, which we obtained the results of. The investigation did. And so, but unless there is an allegation or facts developed during the investigation that specifically implicate the participating physician, then that isn't a focus of the investigation.
Any other questions?
Yeah, I just might add, going to the thought of the chaperones, there is a body of literature about chaperones and differing opinions of the effectiveness. There's been a lot of work in New Zealand done. There's been some work in Canada. If the board wanted to, we could look at that information and the results of those studies at some point in time.
I believe there is a board policy recommending chaperones during intimate exams.
Right. And that usually is the policy, but there's also discussion about what really is an effective chaperone.
Right. And so, you know, I think in the first case, you know, the investigators, you know, spoke with a scribe, and he indicated, you know, that he really didn't see the conduct that was alleged to have occurred, but he's a scribe, so understandably, like to your point, he's not there to, I mean, he is a chaperone in the sense that it's another person in the room, but it's not a true chaperone because he's not focused on that.
Exactly.
Yeah.
All right, any further discussion or questions on this case before we vote? Okay, Ron, I'll ask you to call the roll for voting. Again, this is just the North and Central Committee, except for me.
Got it. Dr. Greenberg. Oh, that's right. Rob Chapanelli.
Yes, to the stipulation as listed.
Dr. Kader.
Yes.
Dr. Eiler.
Recuse.
Yes. Gail Falk.
Oh, sorry, agreed.
Dr. Gades.
Yes.
Dr. Ireland.
Yes.
Dr. King.
Yes.
Ron Philibert.
Yes.
P. Scott.
Yes.
Dr. Kanda.
Yes.
I think that's it.
Okay, that passes unanimously. That closes out the order in case. Back to the rest of the agenda. Other business, David, you have an update on the Michigan Interstate Medical Licensure Compact?
Yes, the update is, they were just kidding. So,
You just wanted to make us all nervous?
Is it April Fool's?
yeah, a bill was passed last week and signed into law by the governor, Whitmer, I think her name is, on Thursday, the 26th. So after much panic and preparation by, probably over 50 boards and thousands of physicians who might be affected by this, and lots of facilities and private practices who were concerned about having coverage. It all came to nothing. And they passed a law renewing the IMLC law for Michigan at the last moment, and it's all over. The good news is we waited. I said, well, we're gonna wait. We didn't really have, we needed to have a plan in place so that we could do it right away if we got to the 28th and it hadn't been resolved. But we hadn't done anything, and I know that some had already sent out a lot of messaging to people and telling people they needed to change their state of principal licensure. So it's all over for us now. We don't need to do any cleanup work.
I mean, why did they hold it up? They didn't understand the legislature or something? Didn't understand?
I think what happened was they got caught up in some petty political disagreements, and it wasn't necessarily anything about the IMLC or the bill. I'm not clear on exactly what happened, but it's over.
Just want to say, in a world as a dearth of good news, it's nice to have some good news. We can celebrate it.
So, yes, and speaking of a dearth of good news, there's another last minute addition to my notes for the agenda. So the Supreme Court issued a decision yesterday, and they found Colorado has a law, or had a law on the books that prohibited conversion therapy for minors. And that's young people who had questions about their sexual orientation or sexual identity. And the law said that it was inappropriate for any medical professional to be providing conversion therapy, like treating them to undo those thoughts. And so a therapist in Colorado challenged Colorado's law. And in the end, the Supreme Court found that Colorado's law was unconstitutional because it bans free speech on the part of the therapist. And the reason why I'm talking about this now is this will affect us in some respects, because there's a provision of law that makes it unlawful for Vermont professionals, and it would be unprofessional conduct as the laws exist on the books right now for one of our licensees to provide conversion therapy. And so that Supreme Court decision, I expect, would be binding in Vermont. And so we'll have to be taking a look at more work for the AHEs than for the board, really, but just identifying what, if anything, needs to be done. So, and next, I was going to turn it over if Dawn is ready. Dawn.
I am.
Dawn was fortunate enough to attend the FSME meeting about trauma-informed regulation. And so she has agreed to provide a little overview on how the meeting went. And welcome back from New Orleans.
Thank you. Ron, did you receive the little internet clip I sent you?
I did not,
You did not.
just your slides here.
Interesting, okay. Fine, that's fine. So, yes, I did attend, a one-day training in New Orleans, about a month ago. And, so I tried, there was a lot of information presented. It was probably one of the best trainings I've ever been to. But I want to focus my comments mostly on understanding the contextual purpose of understanding why we need to understand trauma and how to do trauma-informed investigations. Now, we're not investigators. Scotty's an investigator. We have a new investigator coming on, but mostly we're the decision makers. So I think it's really important for us as a board or board members to understand how does trauma affect people's memory and people's response to inappropriate sexual advances. So Ron, next slide, please. So a little history of this effort by FSMB to look at this issue began about 6 years ago, probably longer than that, but in 2020, under the leadership of our very own Pat King, who was then president. I didn't realize you were president of FSMB. And she was chair of a committee that looked at physician sexual misconduct and issued a report. And this is a little clip of the title of the report. And that report is what kind of spurred the Federation to sponsor this one-day training. I sent out a New York Times article, but Bob said he wasn't able to open it. Did anyone else try to open it?
I did.
I was able to open it.
You were?
It
Okay.
make an account.
Okay, good.
You needed an account, yeah, you
Okay.
have to sign up.
I will try to figure out a way to convert that and send it up because it's an excellent, excellent article. And it cites toward the end the two presenters of this conference, who are two people who founded an organization. Next slide, please, Ron. Thank you. Called Justice 3D. And their names are Nancy Oglesby, who's a career prosecutor and a former career investigator, Chief Mike Milner. Together, they did this presentation from the perspective of both the prosecutor and the investigator, and they were so talented. It was amazing. The goal of all of this is to improve the outcome of investigations involving sexual trauma. And one of the messages they kept reiterating was, it doesn't take malice to do harm. So people who investigate without knowledge about, pardon me, trauma aren't intending to do harm, but your typical approach to investigation is not going to get you the kind of information you want because of the very nature of trauma, which I'll discuss. It's really, the model is not an advocacy model, it's really an investigative model. Next slide, please. So this is just a little information about the goal. Having a process to develop information that is structured, neutral, reliable, consistent, and defensible. And this requires the process be trauma-informed and create an atmosphere of trust with the complainant to facilitate disclosure. Next slide, please, Ron. So there are certain challenges inherent in investigation of sexual abuse allegations. Physicians and physicians' assistants have they're professionals who have a license to touch, and because of this, there's always a potential for inappropriate touching or other sexual advances. Because of the nature of clinical settings being private, Because of the memory and behavior problems that result from sexual trauma, and because of the vulnerability of patients, there are certain challenges in doing these kinds of investigations. Next slide, Ron, please. So a lot of this, or most of this, is about the neurobiology of responding to sexual trauma. And unlike in most investigations where the information being sought is kind of linear and detail oriented, because of the nature of the neurobiology, which I'll talk about in a few minutes, this is a different kind of investigation, and it's highly unlikely that victims or alleged victims will come forth right away for a variety of reasons. It is not at all uncommon for there to be a delay in reporting. And it's interesting, I was talking with a friend of mine a week or so ago about this, and she told me that when she was a teenager or a preteen, she was asleep in her bed, and her parents were having a dinner party downstairs, and a friend of her parents came upstairs and sexually assaulted her. And she didn't realize this. She froze and didn't realize this for years. Something triggered that memory, and she talked to her sister, older sister, about it. And her sister said, yes, the same thing happened to me. So this is someone who's very informed about these issues, but still totally blocked out this experience. So you can imagine how much that complicates investigation. We are animals, and the clip I really wanted to show you was not into, it was a bit, it seemed a bit jocular. It's actually kind of entertaining, but it's actually of a possum seeing itself, startled by seeing itself in the mirror. And when we hear about playing possum or playing dead, we think of somebody who chooses to play dead because they are threatened. In fact, the possum's response, and if you've ever seen I encourage you to Google it. It's really quite amazing. Their response is to just freeze, roll over, bare their teeth, and they are out of it for several minutes until they regain kind of normal consciousness. And that is a survival technique on the part of possums. And we, in fact, we're not possums, but we are animals. And our first adaptive response is to protect ourselves and survive. So for that very reason, we engage in behavior that is designed to protect us, which again complicates attempts to do investigations. Next slide, please, Ron. The slide simply presents some of the normal behaviors that result from sexual trauma. And victims are often thought to be by judges or adjudicating bodies deceitful because they are they don't have a great memory of the event as they're describing it. They might have been delayed in reporting it, whatever, but they're not deceitful. They're merely human beings who had a normal response to trauma, and therefore the investigation is more complicated. And in fact, the presenters emphasize the fact that historically many convictions have failed, or attempted convictions have failed, because adjudicating bodies, boards, whatever, thought the victim was being deceitful, or things just didn't add up, when in fact often memories don't add up when you're talking about trauma. Next slide, please, Ron. So again, this is really all about understanding the neurobiology of sexual trauma. And we talk about tonic and or collapsed immobility. And that's the possum rolling over and playing dead. because that's often the response that victims of sexual assault experience. Next slide, please, Ron. So this slide basically talks about the various responses to threat. And I know basic.
Sorry.
That's okay. Basic kind of Psych 101, we learned that when people are threatened, they either flee, they have flight, or they fight. But in fact, there's a third, more common reaction or response to sexual trauma, and that is to absolutely freeze. And that's called toxic immobility. And it is what makes it so hard for victims to recall the events of the trauma. Basically, the neurobiology involves your more evolved circuitry in your brain shutting down, and the more primitive, basic, adaptive circuitry takes over. And that's what causes the toxic immobility or the freezing. Next slide, please. I will talk about this because it kind of just repeats what I've just said. And so next slide, please. We spent a fair amount of time talking about some techniques for investigation with victims of sexual trauma. And there are some researchers who have created an evidence-based tool called the Cognitive Interview Adapted to Trauma, which attempts to avoid some of the pitfalls that you could be subject to if you didn't understand the various details of trauma. And this tool is used now quite broadly among investigators. And I won't get into the details because, again, we're not doing investigations, but just a few examples are when you're interviewing, the facts might not come out in a linear fashion. You know, most of us are linear thinkers and we think, okay, and then what happened, and then what happened, and then what happened. If you are the survivor of a sexual assault, you don't remember most of what happened. You will remember probably sensory things. What was the color of the wallpaper and what were the sounds in the background? But you will not have a good accounting of the details of the assault. And as any of us who are parents know, if you really want to get information from your kids, you don't start a question with why. And that was another, because people become very defensive. And that was another strategy that they talked a lot about, was just letting victims talk and not interrupting them, asking for clarity of details. I think when most of us are interviewing people to get information about something, we're like, well, back up. What did you say? And how did that happen? And who was there? If you do that with someone who's a survivor of sexual assault, you're likely to see them shut down immediately. And a focus during an interview, a focus on sensory issues rather than temporal issues or sequential issues is likely to provide more important information. And avoiding pressing a victim for details and hoping that the details will come out as the person feels more comfortable and as time goes by is the best strategy to get information. So I know that's very brief. I wanted to keep it to 10 minutes and I wanted to allow some time for questions, but I think that I found it absolutely fascinating to hear about the neurobiology of adaptation to your normal adaptive response to sexual trauma. And it made, so I happened to be in 2 social situations in January when the issue of possums came up. Who knows why? You know, you're thinking Dawn needs a life, but I was so fascinated by possums that I researched them, and I couldn't help after going through this trauma of thinking that's exactly what happens to these little guys. They just roll over and freeze. And we become those primitive creatures when we are threatened in such a way. So I will end it with that. And I would just say, if money were no object and time were no object, I think this would be a fascinating training for all of us. They were excellent, excellent trainers. They had a wonderful way of weaving in evidence and history and anecdotes, and also a little humor, because it's a very serious topic. I think it would be great. But anyways, I hope that's helpful, and I'd entertain any questions. And I'm appreciative of the board sending me.
Thank you, Don. Appreciate it. So sexual trauma is supposed to be, according to figures, very common among everybody. Women more than boys, less than girls, or women more than men. Was any discussion made about the dangers or the concerns one would have with bringing up things either in the investigator or the patient that you're getting information from that might be damaging to them, or in some way, would this particular line of investigation either be traumatic to the investigators or the investigatee beyond which you want to do it? Were there any constraints or anything worrisome about this process?
That's a good question. It didn't come up, but I
can answer it a little bit.
Pardon me?
I can answer it a little bit. I've done actually 2 trauma-informed investigation courses. And the thought process is to allow the survivor to try to drive the train a little bit.
Yeah, right.
You
in control.
you work with their memory recall, like John was saying, it's not going to be in chronological order. By asking certain questions like, do you remember a certain smell? That may trigger a recall of an event. We let them, you even start off the interview with this rapport building, and you just literally just tell them, and you'll probably hear it in some of my interviews, is I'm just gonna let you tell the story. And just let them tell the story. Usually this process isn't one interview, it's several with a true sexual assault survivor. Because you're never going to get everything, and things may even change because they're unlocking these memories after having the interview. They're going to go home, they're going to sleep, then remember something new. So the fact pattern will actually change. And that's where I think where prosecutorial aspects, it looks bad because you're getting multiple different statements from the people. That's just the normal recall. But I think just allowing them just to talk and not pushing pointed questions, but it's letting them freely talk, and it's asking like these sensory questions might unlock those other things. But again, it's usually like multiple interviews. It's not over just a course of one, which we typically just do.
Thank you.
Scotty, this must apply to every sort of trauma. Is that
You can actually, I actually prefer to do the trauma-informed interviewing as a regular interview because it just elicits them just to talk. So that's why a lot of times if you listen to my interviews, I do very little bit of the talking. All the factual stuff's just coming from them, and I'll just ask the little pointed questions to help clarify certain things. I find I actually get more that way than the natural defensiveness of, oh, they said, why'd you do this? Or help me understand that. And that's usually what I'll say is help me understand versus why. That's a totally different aspect of asking the question. And so it gives them the ability to explain that versus being defensive as to why'd you do this? Well, help me understand. You said this, so help me understand that. I don't quite understand that. Even though you may actually understand it, it just gets them to divulge a little more information if they can recall for the trauma-informed parts, which is actually very standard with investigations and investigators nowadays. A lot of us automatically get trained in that style. Because it really does kind of take away this is a pet peeve of mine, that he said, she said aspects of investigations because you're basing things off of credibility at that point. You're putting one person's credibility above another's versus just allowing the facts of the case come out and not using any type of credentials or labels that we give people. It's just that factual information. So every time I hear the meetings, and it's not necessarily for sexual misconduct cases, when I hear he said, she said, I cringe because it's like, because we're supposed to be, as a unbiased board, we're just supposed to take in all the information, then make our determination. But once you start layering it that way, it gives that biased perception. Sorry, I went off on a tangent, but
That's excellent. Thank you, Dawn, so much. You did a great job. I think in our original work group, one of the things we heard from state boards, Scotty, and I think this feeds to your point, was that the investigators would use trauma-informed investigation. They put this information together, they'd come to the board, and then the board was not looking with a trauma-informed eye. And they would totally negate the investigation. So it was clear that if we were going to be responsible for these cases, the boards had to understand trauma investigation, at least to some degree, as the investigator. So that was the whole idea behind this education. And it's taken time to roll that out because the report came out in 2020 and then the pandemic. So kind of nothing happened for a couple of years. And now they're trying to do a little bit, the FSMB is trying to do a little bit each year. But there have been some state boards who have done the training on their own for their whole board.
We did a training.
We did it last fall.
Was it
Was not,
after you left?
yeah.
And, you know, I was gonna follow up, Don
Mhm.
gave me a great entree saying, you know, it'd be great to have the training. I think it was probably 2017 or 2018.
it was right after I started, because I asked to do it.
We had Tom Tremblay, who we were fortunate, he no longer lives in Vermont, you know, Tremblay.
Yeah.
But he is considered one of the experts on the national scene in this.
Great.
And he came in and did I think it was a 90-minute presentation for the board, and we could, you know, we don't have a lot of these cases, but it's, you know, it's one of those things. You need to have the expertise when it does come
Yeah.
up, and it's really
Yeah.
important.
Absolutely.
So I could explore,
That'd be great.
you know, I could talk to him, I could find out if there's you know, but in terms of, you know, time and budget, do it all day, the way that Dawn had the opportunity to see, but we could try and do another 90-minute. He likes coming to Vermont to come visit family.
Come home, yeah.
So,
I just had go ahead.
No, I was just going to say to Bob's question, these folks, the trainers did talk a lot about grooming that can go on, especially in a clinical setting. And clearly practitioners identify people who are vulnerable for a variety of reasons. And you know, the social worker in me says, well, probably one of those vulnerabilities is having been a victim of sexual abuse previously.
Right.
So I think there is certainly that.
I was just going to add, one thing maybe you didn't touch on, we had two survivors or victims speak before our committee. One was Marissa Hochstetter, who's been very public. She was abused by Dr. Haddon at Columbia, the OBGYN. I don't know if you remember Andrew Yang's wife was abused by him. I mean, a lot of people. He lost his license in New York, but in any event, she's been very vocal and she's extremely articulate. And she talks about the trust with a physician, especially someone you're seeing for your prenatal care, and just never imagining. At first, you just are not sure what's going on and you can't really understand. You feel like you can't possibly be right in the interpretation. And then if you if something happens and you don't fight, push back or whatever right away, you carry this immense amount of guilt.
Yeah.
And
Well, why didn't you push back?
guilt and shame.
Yeah, exactly.
And it's, so you don't want to talk about it. You don't want to share it. You're shameful, you feel guilty. So there's this whole,
And that's the delayed reporting aspect.
Yeah.
When it shows up years later, they'll actually say something.
good, thank you.
Thank you.
The New York Times articles,
It really is an excellent article. Yeah.
I can, yeah, I'll look for that this afternoon and I can gift articles,
Okay, that would be great. Thank you, because I might not be
send
able.
that out to everybody.
It really is worth the read, I think.
Great,
Thanks again.
I think we're to the General Assembly pending bills. Do you wanna take that in?
Sure, yeah, we're free. If you want, do you want to do cases first or you want to go with? This,
I'm just
I
going
have
in.
may I ask a question?
Yeah,
We blipped really quickly past the Childs v. Salazar Supreme Court case regarding conversion therapy. And I wasn't sure, David, if I understood your point about that, because I think this will impact us quite a bit. Could you just clarify what you were wanting us to know?
well, I was just bringing it up. I thought that probably some of you had seen it in the news. It just came out yesterday, and just making the point that it's going to be something that we're going to have to look at. I think that the Supreme Court case would be binding on Vermont, and it would prevent Vermont from enforcing the existing law as it stands. And so I don't know. We have to look at the there is a provision in the Medical Practice Act that speaks specifically to that law, I believe. And so we'll have to look and see if that needs to be taken off the books, or if it were to come up that we had somebody who was a licensee and was being investigated for having violated that provision, we would have to take that into consideration at a minimum.
Yeah.
and
I'll
then,
just put this on the horizon because we'll see how it unfolds. But the Supreme Court, in the wording that they gave in the majority opinion, they essentially said that speech is not conduct, which is really disturbing, in that for so many aspects of medicine that use words rather than procedures or whatever, speech absolutely is conduct. And so I just flagged this decision as something that I suspect will have farther reaching implications than it appears to immediately, and put that on people's radars.
And Evan, this was a topic that when Kurt and I attended the FSMB attorneys workshop, they flagged this litigation. They flagged the discussion of portions of medical treatment as speech and the implications of that for professional discipline that could come up in very concerning ways in a variety of contexts. So it's certainly something that attorneys are discussing in this context, that they're exploring the implications of it, and we may start seeing arguments and defenses in our cases related to that. I suspect, especially with our psychiatrists, where speech is so much a part of that practice.
Yeah, but and other specialties too. I mean, physicians and physician assistants spend, unless you're doing surgery, there's a lot more time in an office visit spent talking to people generally than there is in other types of practice. So it looked to me as though this is one of those things where I wasn't surprised that the majority decided as it did, because the Supreme Court has gone against LGBTQ people repeatedly over the last couple of years in a variety of ways, and that was the substance of the case. But I think that Ketanji Brown Jackson's dissent really nailed it, that, you know, if speech isn't conduct, you're opening up a wide variety of potential problems in medicine and in other fields. You know, if you give someone bad legal advice, is that just free speech rather than conduct? You know, professional conduct, you know, or you give them bad financial advice, you really didn't do something unprofessional. Anyway, I put a pin in that and take a look, because I think we're suddenly in a new era, and, you know, buckle up.
Thank you for bringing that up.
I agree with Evan's comments on Ketanji Brown's dissent, and I thought it was interesting. She also brought up states authority over the practice of medicine within their jurisdiction.
That's us. This is really salient, you know,
state-based.
in a way that, yeah.
It's interesting that they took the case, because if I understand this correctly, there was no enforcement of the law in Colorado. And I don't know that I've heard of any in Vermont either. So the court took it up without even any lower court action.
And I was surprised that they turned it on free speech.
Yeah.
I was like, really?
Yeah.
I think they had to, in order to tack it into the constitutionality, which they're required to do.
Okay, why don't we move on? Sure, yeah, it looks like we have, I mean, those are the two big things we have left, is the executive session or the bills.
So, yeah, I'll go with it, just checking with you.
Yep.
So the first one I'm going to talk about, because we probably will very soon get a request to testify on this one again. And that's S-163, an act relating to the role of advanced practice registered nurses in hospital care. And this one we talked about last month briefly. And so Vermont law now requires each person admitted to a hospital on an inpatient basis to have a physician, either an MD or a DO, as their attending. And so the bill is passed by the Senate, adds APRNs to the list of providers who are eligible to be an attending. And so that passed the Senate in late February on the 27th, and was referred to House Healthcare. And so Matt went to House Healthcare, and he was invited in to testify, and did so a week ago today. And he provided, I'll let Matt speak to that, but I would say he provided a lot of, it was really good, I think, Matt, the way you put that on and gave them an overview of the relative education and training of each of the professions under consideration, and just sort of establish a rapport with them as an expert. So
what, and I've already been invited back, so what I really need from all of us is they're asking for a consensus statement from the board. The issue at hand is that they modified, so what passed the Senate is a bill that would allow APRNs to oversee inpatient care as the attending of record. And there's two places within state statutes that it modifies. So it modifies the Patient Bill of Rights that currently says it has to be a physician, and it modifies the licensing rules for hospitals that currently says you need a physician as your attending. The bill that passed would add APRN to both of those. The House committee is entertaining an amendment to that to make it APRNs or physician assistants. And so they asked me to testify on what the board felt. And I said, well, the board hasn't talked about it because this is new since the last time we met. But what I did go in, I went and I explained the differences in training and what each of those different degrees represents. And my ultimate statement was the decision to go from a physician to a non-physician is really the larger decision. And if you've made that leap, saying that a non-physician can be an attending, then there really is although the training and the approach to practice may be different, the body of knowledge between a physician assistant and APRN is probably much smaller a difference. And that if you allowed one, the logical conclusion is that you should allow the other. So what I think we as a group need to decide, and representing physicians and PAs as a board, do we feel that that change, that jump is appropriate to go from a physician to a non-physician APRN or physician assistant? Are we comfortable with that and agree with that? Do we not feel one or the other? Do we, put a modification? I think my largest argument was that the amount of, what I worry about more are the fresh grads, right? And I think if we, call a spade, why are we even looking at this? And it comes down to money, right? It's much cheaper for a hospital to employ an APRN or a physician assistant. So in some ways, we're following the money. But should we do that? And can we support that? And I think that in my mind, the biggest issue is the fresh grads. And, does somebody who comes out of training with only a couple of years of training versus the, 7 to 10 years of training that a physician coming out of residency would have to oversee an admitted patient? And just by the nature, somebody who's being admitted to the hospital is already sicker than, 90% of the other patients seen on any given day in the healthcare system, probably more than that. You're already self-selecting a patient population that is sicker. And what do we feel is appropriate for them to be managed at what level of a degree? And one of the other points that I made to the legislature is the degree itself really doesn't make the difference. What makes the difference is the experience and the training that you've had. And I've worked with plenty of PAs or APRNs that have 20 years of experience that are far more experienced than a fresh grad physician. But I think that the first couple years coming out of training, that's a lot of pressure and a lot of responsibility on somebody with a lot less years of training. I would almost wonder if we recommend, sure, but maybe they should have they should be at least 2 years from graduating training, or 3 years from training. 3 years might make sense because 3 years is what most medical residents are at minimum 3 years, or they're between 3 and 7 or 10 if you do fellowship training. So, a physician after they graduate medical school is going to have at least 3 years of residency. So maybe saying that we'd recommend an APRN or a PA has 3 years. I don't know. I'm bringing this up. This is what I discussed with the board and said that I would come back. I got an email yesterday saying, please don't forget, we expect you to come back again with the decision. So they've already asked for me to relay, and I'm happy to relay what we come up with as a consensus.
When you use the term training, what I think of is the outpatient world is very different from the inpatient world. I mean, and I think most of us are trained, well, as medical students, we're in hospitals and that sort of thing. I don't know how much training a nurse practitioner or PA has in taking care of patients in an inpatient setting. I think of it as primarily getting prepared for an outpatient setting if you're a nurse practitioner or a PA. That's the way I think of it. I can just say in our own hospital in Brattleboro, we've had a very, very accomplished nurse practitioner as an attending for several years now. And she is somebody who was just extremely skilled. She was a nurse from the time she was 19 or 20, and then she became a nurse practitioner. And this woman is extremely skilled. And physicians have worked with her. But it's almost like you have to have training in an inpatient setting to become a nurse practitioner or physician's assistant, to be in that position. To me, it's so different from the outpatient to the inpatient.
Yeah.
Completely different
I
world.
think there's a lot of variability in training, and one of the things that, PA training is a little bit more organized at this point because there's only one regulatory agency. There's two regulatory agencies for APRN, so there's a little bit of a difference there. Most PA training is hospital-based. It's very much more similar to physician training, just the way that it's arranged and oriented.
Okay.
Most nurse practitioner training, not all, because there's a lot of variability right now, but there's a lot, you're taking somebody who's already a nurse, meaning that they have a full-time career. So for them to go back to school, it's probably being done in a serial manner rather than a parallel manner where you give up everything, you go to school and you train, right? Like you go to medical school, you're not working another job at the same time, whereas a lot of nurse practitioners are working as nurses while getting their degree. And so it's one class after another rather than taking 3 classes at it. So I mean, there's a lot of variability in that training.
Right.
Some get more experience than others, and I think it's hard to account for that. I mean, we still need to rely on hospitals, right? You can't, if I am not a surgeon, I can't get privileges to do surgery. So there's still the role of the hospital and the credentialing program to decide whether they have their, the right credentials to be operating as a hospitalist. But in many ways, it is advantageous for the hospital to be somebody who less salary.
Correct. Yeah, eventually.
But they have to balance that with somebody that's competent and isn't going to have rebounds and provide legal liability as well.
Right. Complicated.
You may have touched on what I was confused about. So in an outpatient setting, I call up and I ask to be, for a new doctor. They give me a nurse practitioner. In the hospital, I'm a little bit familiar now. They have hospitalists. And is it my understanding that if I had a doctor, that doctor would not necessarily follow to the hospital as an attending? Is that correct now?
Correct.
Okay, so you're talking only about hospital hire then?
Yeah, so at this point, it's very rare for outpatient doctors to manage anybody in the inpatient setting. In the inpatient setting, the hospitalists and their team will take care of
You're
it.
talking about a whole new person who act as a.
Yeah,
okay.
exactly.
Thank you.
And what happens right now is that there are many hospitals in this state that utilize PAs and APRNs. And what happens is ultimately a physician, MD or DO, has to actually sign off. They're supposed to go in and see the patient and talk to him, but to be honest, the PAs and NPs are doing almost all the work. There's just an oversight, and some systems work better than others and have a team approach where they go in together and one of them will do some of the work, but they'll oversight and say, hey, the physician's job is, hey, did you think about X, Y, and Z? I work with both, and they're, both PAs and NPRs, and they're excellent.
And how do you see the differences between the residents and the PAs and the nurse practitioners?
I mean, I think it depends on the amount of training. I've worked with, if you've been any, like Bob's describing here, this nurse practitioner, they're probably just as good as any of the physicians working in that role that have been out for, 2 or 3 years. It's hard to group people based on their degree because experience is so much of the practice of medicine.
I like your idea of certain number of years experience.
So the way that this is, the S-163 is written now, it sounds like they've all made up their minds.
The way it's written now is for APRNs.
Correct.
And it's a bill. It hasn't.
Right, but it's passed out of.
It's gone out of the Senate and it has to be approved by the House and then voted by.
Okay, so if it passes as is now, PAs are at this point not gonna be hireable in an in-hospital setting. Because
Yeah. They,
they can be hired, but it's gonna be a pain in the neck because they have to have a, so in the end, they're not gonna, they're disadvantaged.
Yeah, I should say, they invited the board and specifically Matt to come in and testify to speak to whether or not they should add PAs. So they're not, I mean, they're not against it, and this happens all the time with
Right,
bills
but
where
the,
they get amended, you know, they're passed in one body, which was passed in the Senate.
right,
And you know, that bodies, they can say, well, we're gonna approve this, but we vote to amend it to include PAs. And then there needs to be back and forth between the
Right,
Senate.
but-
What they're looking to us for.
right, they're looking at us, and there was a very, very effective PA speaker who is a critical care PA who runs the ICU at Rutland.
Is it Leah?
Yes,
Yes, she's very good.
she was so good.
Yeah. And
spoke.
she's told me about the credentialing at Rutland for NPs and PAs to be hospitalists. And the credentialing is very good.
Yeah.
Like, you're not just gonna be hired and be able to do X, Y, Z.
Yeah. So that's some of it is how much gets rolled into law and how much do we leave at the liberty of the hospitals in their credentialing process?
Well, I think it's my opinion that it definitely should be in the law. Because the other way, I mean, Rutland Hospital might be just that much ahead of the curve, you know? And they've got a little bit more money than some of the other hospitals, but, you know, and then the other hospitals could just say, oh, well, this fellow graduated last week and we're gonna hire him for this because that's what the law says we can do. So if it's in the law, that won't be, you know.
Are there administrative rules, do you know, David, that go along with this? Because very often those kinds of details are written in administrative rules rather than the enabling legislation.
So there is in statute already sort of something you might use as a proxy for the APRNs. And that is the transition to practice, which they've been trying to get rid of recently. Pat, I'm sure you remember when in 2011, when I first came to the board, they were on an all-out effort to do away with the requirement for collaboration agreements. And we said, okay, we'll agree, but there needs to be this transition to practice. And it provides for so many months of and minimum number of hours over those months before the requirement for a collaboration agreement with the physician goes away. And then also if you change your focus or specialty, then you need to do another, not a longer period, but you need to once again have a transition practice period with a collaboration provider. So you might suggest that they say to be an attending, you cannot be in the transition to practice period. If you wanted to have something like that, and then you need to come up with a proxy for PAs, I don't think you could propose it for APRNs and not have something similar for PAs.
It would make it less confusing to have it in one piece of legislation than this other one out there and, you know, okay, this is this and this is this, unless you refer to it back in the legislation.
Well, it would be in this one piece of legislation and say they can be an attending.
What is the?
Only if.
Is it 24 months? What is
24 months or 2,400 hours of practice.
Yeah. So just add that in for both.
It's at 24 months or 2,400 hours. That's the transition to care for APRNs.
Yes. I guess it's an and.
Yeah.
Oh, it was and.
24 months and 2,400 hours of licensed active practice.
Yeah. That makes sense.
So, yeah, I have an opinion on this. I have some questions. First of all, I think any decision should not be based on the exceptional person, such as you may have it at Rutland in the ICU. It's got to be based on the average person, because those are the people that will be hired to do this job when hospitals have a money crunch. Secondly, I'm wondering what the hospital association, how the hospital association weighs in on this. Thirdly, whatever the degree of the person who is the attending, whether it's a PA or a ANP or an MD, they'll be referred to as doctor. And in the patient's mind, who's on the gurney being wheeled into the room, that's the doctor. And the patients perceive it this way now, whoever they see. So I think it's really important to understand the patient's perspective. And now, my opinion on this is, for over 40 years, until about 3 or 4 years ago, I was an attending physician at a small community hospital, Copley, Nashville. And you have monotony with admissions. You have the pneumonia, you have the abdominal pain or the abdominal obstruction or the kidney infection, and they're managed in a certain way. And then all of a sudden you get the weird one, the kidney infection that turns out to be the second aneurysm. And that is, I learned late in my career that they call it medical practice because of the stuff you learn over the years, and you really do learn. It's judgment. People say, "Oh, you're old," but it's judgment, it's wisdom, it's having seen weird stuff over the years. And medicine is not algorithmic. And many of the practitioners practice algorithmically because that's the way. And many physicians don't practice algorithmically because they didn't learn it that way. They didn't learn by algorithms. And especially in the hospital situation, there's so many weird things, that complications or confusing diagnoses, that if I'm in a hospital, I'll be happy to have a really good, competent nurse practitioner, PA, take care of me, as long as they're working in a team with a supervising physician. And I would wager that there's probably not a really good database of hospitals, research database of hospitals that have been doing this for several years, that can demonstrate outcomes with attending physicians versus attending PAs, attending nurse practitioners who are not supervised. So I have, now judging from David's report, it looks like that whatever the medical practice board thinks about the legislation, stuff's got to get passed anyway. Cynically looking at, skeptically looking at it.
I think the view of VDH, the Department of Health, is that this is happening in other states. It's the trend. The trend is going in one direction, and the VDH is sort of picking its battles and feels like there's some other issues, some of the scope of practice issues and that are yet to be discussed today, and the other matters that they think are better to let one go. But
so I mean, I'm all for teams, and I'm all for teamwork in consultations. This concept really scares me, and the patients are not going to understand the degrees of whoever's taking care of them.
The other thing that we've talked about this in the past is that the PAs are regulated by our board. So we are a board of attendings regulating, an MD or a PA who might be an attending. But the APRNs are regulated by the nursing board. And there's maybe one, I don't know how many APRNs are on their board, and I would doubt that they'd be a hospitalist. Maybe yes, maybe no. My only point is that if people are going to do like work, they should be regulated by the same board. And I know that's a big thing to say, but that is really what the public would expect. The public would expect, they think they're the same people, they think they have the same expertise, the same ability. They should be regulated by the same board.
We had that discussion when, in 2011, when we ended up getting, the new language about APRNs and doing away with the collaboration agreements. And at that time, one of the points we made was, well, if you're taking the requirement for physician to be part of the equation with the APRNs, that heightens the concern about how APRNs are regulated. They have an APRN subcommittee, and they agreed to allow the Board of Medical Practice to have a member act as the representative to the APRN subcommittee, and that's Dr. Ireland has taken that on and gave you all some important information based on his participation in one of the meetings.
Yeah, there's been one meeting over 2 years, and the only point was about dissolution of the transition to practice agreement.
So you don't see any cases at all, or?
I haven't.
Does that mean there are no cases or?
Well, the public also thinks that DOs are managed by the Vermont Board of Medical Practice.
Right, but they have a DO board who are, and you could argue that we should all be together, but at least they are like, trained, so.
I'm just gonna jump in here since I'm never getting called on. It's a two things. Pardon me?
Sorry, I didn't see your hand. Good.
Oh, okay. One is point one. It makes no sense to differentiate between the PAs and NPs in this. Point two, I agree. I'm very opposed to getting rid of teams and supervision because of the obvious corollary, which is that if, regardless of what the downstream costs are, if it's cheaper upfront to pay a PA or an NP and have them be the attending, then soon there will be no physicians in that role. That's where that goes. And there is a difference in means based on level of training. It doesn't mean when you have two overlapping bell curves, it doesn't mean that someone in one group can't be superior to someone in the other group, but it does mean there's a difference in means. And that's what we have now based on years of training and model of supervision. And, as someone who is now an older person myself with older adult family members, there have been too many situations just in the last few years in which the initial contact, including in an inpatient setting, has been with a nurse practitioner. And I can't tell you how relieved I've been when the physician has come in and contributed more than was going on in the first round with the NP. So I don't think it makes sense to differentiate between, to disadvantage PAs versus NPs. But I also don't think that it makes sense to get rid of supervision and go to a model in which the hospitalist will now be a PA or an NP, not an MD or DO, which is where that will go over the next 5 years for economic reasons. That really concerns me greatly. So I don't support anything that gets rid of the team and supervisory concept.
Was there some discussion on hospitals trying to maintain some kind of a team construction?
No, this is really being pushed, especially from the critical access hospitals that are already basically staffing with NPs and PAs, and a doctor comes in, they're staffing 24/7 with them. And then at some point, a doctor comes in for a period of time during the day and signs off on the charts, presumably sees the patient and signs off on the charts. But it's sort of happening in practice with the sign off. And then this would get rid of that, need for that level of sign off.
So they'd all be independent players, you're saying? More or less.
The last time I had a family member in a Vermont critical access hospital, it made a big difference when the attending physician came by. I have been okay leaving that entirely in the hands of the NP.
I have to clarify, did you say that you're looking to end the physician, looking at the orders, signing them?
Matt, could you break it down and like, what are the issues you need, like, it sounds like there's a couple of issues. One, 2-3 years of supervision first. Then there's also, the PA, including the PAs. And then, a couple of other issues, whether it's, board regulation or, but can you?
Yeah, I mean.
We might be able to.
I think the way it is right now, it's, do we support the bill as it stands, which says that APRNs can practice on their own as attendings? Do we want to modify that to say APRNs and PAs? Or do we not support this at all? If we did support it, would we support it with reservation, meaning putting on a recommendation for a time frame, such as the transition of care? I think that's the way I break it down in my case. Does that help?
Yes.
It sounds like this thing is running.
Yeah.
I think it's going.
Yeah. And that's the reality,
I
so.
think the reality is it's gonna pass in.
So how can we change it?
How can we,
Yeah.
that's the way I was looking at it, is this is likely to pass, but how can we do the best that we can to provide the best protection to the patients that are gonna be in these hospitals in this setting? Yeah.
Yeah, so listening to everybody, I feel like we're deeply concerned, and if we had a choice, we would say, don't do it. But it doesn't look as if we do have a choice. It looks like this is happening. And what your point that PAs and nurse practitioners are not significantly different is worth saying. And then because of our reservation, it sounds like we should be also recommending that any PA or nurse practitioner that's given this responsibility should be given that responsibility only after 2 to 3 years of practice in a hospital setting.
I think that might be the best compromise.
I think your points are well taken. The experience, the fact that PAs and advanced practice RNs should be kind of looked at equivalently in this setting. Another point there. However, I think my advocacy would be for this group to take a stand to say, this is a bad idea. I think it's really important personally to go on the record about that, because bad stuff could happen down the road. And I think it would be good in the future if that happened. At least this board had made a stand. Probably would be ignored.
Well, if that happens, would that give less credence to the suggestion of the adding the PAs and having extra training requirement? Do you think it waters it down? Because I think that from what everyone seems to say is that this is going to go forward. The legislature really wants it to go forward, and so therefore it is going to go forward. And the best thing to do is to modify it.
I don't think it weakens it. I think that it's possible to say the opinion of the board is that this is not a good idea, period. However, we are gravely concerned about the way that it is currently constructed, and therefore, it's possible to do both. I don't want to be on record as saying that I supported this. I think that there will be issues down the road.
I think that gives me enough that I can come back. I feel Actually felt very comfortable with them. I had a pretty good rapport with the committee. And I think that I would feel very comfortable going and saying that honestly, the board did not support it. However, we feel with the political pressures and the headwinds going the way that they are, that we would recommend, if it was supported, these changes. One, PAs and APRNs be treated equivalently, and two, that there be a minimum recommended time frame that they were in practice before being put in this position.
I'm just wondering if there might be any openness on their part, if you suggested that, based on the concern, these are what the concerns are. We think that people who would have the best insight to the difference it might make is the people who are coming in and reviewing the work of the PAs and APRNs and signing off on it during the day. And we think it might be good for you to hear from a couple of them and ask them what they think about it. But if the hospital is for it, they might cherry pick.
Yeah.
Yeah. In addition, the people who are doing, I think it's unlikely that the hospitals will immediately start picking new grads. But economics will favor less experience over time.
Yeah.
And I will say that I've talked to, before I was going, I talked to a bunch of people, and since I've gone, I've spoken to a bunch of other people, PAs and APRNs. And I will say that my more experienced friends who are PAs were very much in favor of it. But I also spoke to several that were a little bit newer grads who felt that they were thrown in as a fresh grad into positions that they were uncomfortable with. And these were mostly outpatient, but thought this would be a bad idea because they thought the same thing would happen. So I've got APPs who ride on both sides of this line as well.
Yeah.
A quick question as far as the legislature goes, because I'm not familiar with that. So the committee that you're talking to, is it the same committee that's also working on S64 and H237? That the same committee is?
I honestly don't know. So that this one, although it's an S bill, started in the Senate, is now in the House. So it's now the House committee. I have actually been talking to both the House Health and Wellness and the Senate Health and
Okay.
Senate Health and Welfare.
Senate Health and Welfare Health, yeah.
Okay.
They're
But-
slightly different, but
But the same committee sounds like they're doing all of these.
Well, there's different people. And the bills that we're going to be talking about, some of them, like the scope of practice ones tend to go to government operations first. But then because they affect medical care, they go to Senate Health and Welfare. The House and Senate are different too, and the committees.
Yeah. But it just seems like what's happening. I didn't know if it was the same group of people that were just saying, optometrists can do surgery. And
Yeah, I think the optometry went through the same, that was in the same Senate Health and Welfare. And I'm getting confused.
Senate Health and Welfare.
Senate Health and Welfare.
And there are members of both bodies who are very interested in these issues and are very open to any expansion of scope, any, things like this, with really it's kind of an expansion of scope in a sense, but, yeah.
I think the best you're gonna be able to do is put some guardrails on it. And to include the PC.
Yeah, I think the pushback from the committee is gonna be, we need better access to care or more access to care.
Right.
But as a patient, though, do I want any access to care or do I want competent access to care? That's gonna be. that's the
Access,
issue.
quality, and cost. Quality is a big one.
That's a good word. That's a good word, competence. Yeah.
Can I ask how the hospital association comes down on this? And are the critical access hospitals the primary drivers of this?
I believe so.
Yeah, yes. I think their enthusiasm may have been muted a little bit because of a range of opinions about it amongst their membership, but in the end, they're for it because of the number of.
Vermont
Critical
Medical
access.
Society testified as well. They came down neutral.
I mean, I'm an advocate of critical access hospitals, but if that's the driver and that's the situation they're in, they should consider whether they should continue to exist.
Well, that's a big question too. I mean, honestly, there's a lot of discussion about that.
Right. So it's really a question of how much do you compromise in the name of access? Before you start compromising quality.
And there's a lot of.
But
push
is
from-
it really access or is it really cost?
I think it's cost.
Absolutely, all three, quality,
just-
cost, and access.
It's actually been my question the whole time we've been discussing this. Is this really being driven as a cost saving measure? Yeah, so how,
How awful did you say?
I did.
Yeah, but that's the thing, they will never say cost. They will always say patient access, because that sounds better than, we don't want to pay the money.
And just for reference, we talk about critical access hospitals, more or less defined as 24 or fewer inpatient beds and an emergency room. And actually, there's so many critical access hospitals closing across the country that they came up with a new category of basically standalone emergency rooms, because for obvious reasons, is as much as they may have wanted to have inpatient services available within, especially in the, the states that have more square miles. You really need to have the emergency room with available. And so, this is even more of an issue in a lot of other states where there are lots of hospitals are closing for cost reasons.
The cost data also has, the right questions have not entirely been evaluated, in that there was a study that came out, I think 2 years ago, looking at true costs in emergency departments when patients were seen by nurse practitioners versus by emergency physicians. And there's been a huge move in recent years to move towards more NPs and fewer MDs or DOs, because the NPs can be paid a lower salary. And so the study actually was started by a physician administrator who wanted to go to more NPs for cost reasons. And it turned out that the care that they provided was more costly than the physicians, because even though their incomes were lower, their ordering of tests had a different pattern than the physicians, so it was more expensive, and more patients returned to the emergency department after a brief period of time, so that the cost to the system was higher. And I have not seen an equivalent study looking at who's you're attending when you're a hospitalized patient and what are the costs. It's all just looking at upfront costs, and that's not the data that's really needed if you're going to use cost as an argument.
I think, can I just say one thing? That currently, you have sort of inherent guardrails, because let's say a nurse practitioner is working with a shift. There's a sign out to the next shift, and that shift, there are more physicians, I think, right now than non-physicians on the inpatient services. So at least there's that kind of contact, and I believe, they take over and look at the patient the next day. And so I think that's helpful. The fact that there's always physicians involved in the care of the patients, even if, nurse practitioners are involved. What worries me would be if you had a situation where you wouldn't have any people with a physician's training, in a hospital setting where it's all nurse practitioner, because I don't think that would be good at all. So, Matt, you've got a challenge here. We appreciate your situation, and thank you for doing it.
All right.
So, Matt, do you want to try and have a formal statement that you can present or?
I think I can, I think I'm basically just gonna summarize what we discussed. I don't know that I need a formal opinion from the board. I can say that the board had a heated conversation.
Robust.
It's robust.
Thorough.
I'm taking notes, I like that. Robust conversation. Heated and.
Nuanced, detailed, thorough.
I've got a bunch of good notes. Okay, why don't we, there's a couple of other bills.
Sure. So H 237 is the prescribing by doctoral level psychologists, and it was passed by the House last year and sent to the Senate and referred to Senate Health and Welfare last April, a year ago today. And it was passed out of Senate Health and Welfare with amendments on February 27th of this year. It went to Senate Finance, and I sent you all a link to the amended version of H 237. And it's on the agenda for a possible vote in Senate Finance yesterday. And I don't think, I haven't been able to get into the legislature website this morning to let you know if that vote went through.
I just got an email about it 15 minutes ago. And they did vote it through, and they actually took out the previous guardrails that had been put in, so that the version that they got said that a doctoral psychologist could not prescribe for patients over 80 years of age, and they took that out. So at this point, they would not be able to prescribe for people under 18 or in pregnancy, but could prescribe for older adult patients with no restriction. So at this point, it goes back to Senate Health and Welfare to look at the amendment and see if they agree with that or not. Older adult prescribing, whether it's for psychiatric medications or cardiac medications or anything else, is pretty different than prescribing for someone who's 30 years old and healthy. You know, liver and kidney functions change, enzymatic functions change. There's more potential for drug interactions. People take more medications. I'm really, really disappointed in that. But there is still room to comment on that. And, you know, you can, if you're interested, you can contact the Senate Health and Welfare Committee about it.
Yeah, as Evan said, you can write. I'd say if you want to comment, you could mention that you learned about it through your participation as a Board of Medical Practice member, but you're commenting on your own as an individual. And I think that may have some weight with them.
Matt, I have a question. Do these prescribing psychologists have an on-call situation for night? Because in terms of side effects, you know, physicians have on-call people covering at night. I just don't know if once they start prescribing, the side effects we're talking about are going to occur, obviously. And they oftentimes occur during the night. So the person, who would they call? In other words, they're leaving it to the primary care call system to cover that. It would seem to me that should be part of the responsibility if they're going to prescribe. They should have a call, 24-hour call
They're
system.
required to have a collaborating physician, but I don't believe it says anything about, you know, it's sort of like the participating physician agreement with a PA. There's no temporal requirements on that. So
Well, they probably call it primary care, but it's just one more thing.
Mhm. I put the members of the Senate Health and Welfare in the chat. I don't know if folks can see that or not.
Yeah. Could you send an email?
Sure. I'll send it, I'll send it to Ron. Who can,
I really agree with what Evan's saying. When I read the bill, I was very pleased to see the restriction on prescribing for people over 80. Because I spent years as an advocate and guardian for my father, who had very complex psychiatric issues when he was in his late 70s and 80s. And he was lucky enough to have a gerontological psychiatrist who just kept pointing out and talking about the difference between aging brains and younger brains and how they react to the medications and how it's just a whole other ballgame to prescribe for somebody with a serious psychiatric problem if they're over 80. So, yeah.
another thing that's not really addressed in this, I mean, I think it's worth bringing up the who's on call question. But another thing that's not really addressed is with the pregnancy exclusion, what happens if someone that is being prescribed for by a doctoral level psychiatrist becomes pregnant? Like, what's the mechanism? Are they just told, I can't care for you anymore, go find somebody? Or should there be some arrangement in place in advance? There's, half of pregnancies are unplanned.
Good question.
So, any more comments on that one? I mean, it's fairly far down the road. I mean, it could be the last chance to be heard on it. And then after, if it does come out, they work to an agreement on the amendment and the Senate passes a version that's different from the House. There'll have to be a committee of conference to work out the differences. Then ultimately, well, you still will have, before that, getting to that point, you would be able to send comments to all the senators. The full bodies often are guided in large part by the committees, but if they get enough public input, they may hesitate to pass something. The next one on the list is.
Yeah. Can I go back to 1 second? I thought more about what you had asked about whether we should have an official statement. And I think maybe it would make sense to have one for me to present. And I just picked something that I would like to propose, if that's okay. Sorry to jump around a little bit. But I need one clarity from here. The transition of care for APRNs currently 2,400 hours and 24 months of practice after graduation or after passing their boards.
It just says licensed active practice initial role.
It has to be after licensure.
Yeah.
Which would be after. Okay, so after initial licensure. Okay, so if everybody's in favor, what I would do is use this statement and then spend a little time explaining all of the things that we discussed. And what I wrote here was, overall, the board was not in favor of transitioning attending coverage for inpatients away from physicians. That being said, we are realistic that there's significant pressure to move forward with this bill. In light of these pressures, we would recommend treating PAs and APRNs similarly. We would also recommend a minimum level of experience similar to the APRN transition of care policy that requires 2,400 hours and 24 months of practice after initial licensure.
But do you have to clarify that the practice would be in a hospital setting?
Yes.
Mhm. I also would put the shoe on the other foot instead of saying, hey, we're being realistic here. That sounds weak. I would just say was not in favor. However, we were gravely concerned about the potential for clinicians with low levels of experience, recent grads, et cetera. You know, to hammer home the point that that really is a huge problem.
Is it a perception or do you have data to back that up?
I think that was the substance of our discussion.
I'm always concerned with extreme language, like
Yeah.
gravely with the legislature. That's all.
Particularly concerned.
There you go.
I'm just thinking how, it's like times have changed, the input of physician level people used to be listened to more. Years ago, I had that impression, but financial aspects are just taking over in terms of decision-making on law, when it comes to laws and legislation. It's a bit disturbing. You have a sense of powerlessness and concern about safety. I know, just a thought. Just.
I don't know how everybody feels in the room about this, but is it, I think saying not in favor, the board is not in favor of this, could be stated more strongly. Okay, now maybe that represents my opinion and not everybody's opinion, but
I think that's what Evan was talking.
I think it, this could be dangerous or potentially dangerous or bad idea. I don't know. I would favor
Deeply
a
concerned.
little bit strongly.
It says that overall, the board was opposed to transition of attending coverage for inpatients away from physicians. We have significant concerns about practitioners with less training. That being said, we are realistic.
It's training and experience.
Training and experiences.
And thanks for taking the heat.
Yeah, that's okay.
They're a pretty gregarious group up there, actually.
I get yelled at, and sweared at, and spit on by patients all the time.
Legislators are small potatoes compared to.
It sounds to me, the way it's worded right now, it sounds a little more gatekeepy than I think we intend it to be. Okay. We don't want to move away from physicians. Well, of course not, but we don't want to move away from physicians because of safety concerns, not because we're trying to protect.
Right, perfect. That's a really good point. Right.
Safety, it's all.
Because
About
about public with about city.
And who's gonna take care of us?
It's our board.
I also don't go with we're being realistic here because I think it's realistic to stick with teams. You know, I would just say we're particularly weren't in favor and are particularly concerned about the following.
It seems like realistic says, oh, they're not in favor, but they're okay with it.
Yeah.
That's what realistic says to me.
Mhm. I don't think we need to have a juxtapose there. I think it can just be opposed and particularly concerned about this.
But we still want to offer a secondary choice to that.
Right.
Well,
We're particularly concerned about this and therefore.
You don't want to be ignored in writing anything in particular that you can get in there. And they may be open to, adding something. I mean, and the other thing to remember about the process is if things don't go well the next couple of years, we can come back.
Yeah, we can change.
Usually once the horse leaves the barn, we're I think you only get one bite at the apple for most things.
I wouldn't say that, but that's fine.
I mean, do you have any examples in which there's a reversal?
Well, I'm not saying
Scope-
reversal. I'm saying sometimes the laws are improved on an ongoing basis. And if things don't go well in the hospitals and there's some actual examples that you can bring back, you can ask them to revisit it.
Yeah.
If you have a couple of legislators who are willing to bring the bill to light, but
I just wondered if there were examples of that from other types of laws or from a similar type of legal situation.
I think you see it all the time with laws. They modify them continually. Every year, they have a new set of modifications to the various statutes. They make it better and some of them don't, but.
Sure, but I'm not aware, I mean, I've been following credential related laws for a long time and I'm not aware of that dynamic having happened. And so if someone had an example, I would look it up and learn from it.
Process.
Okay, so I wordsmithed again. Overall, the board was opposed to transitioning attending coverage for inpatients away from physicians. We have significant concerns about practitioners with less training and experience and the potential safety and quality ramifications. If this bill were to proceed, we would recommend treating PAs and APRNs similarly. We would also recommend a minimum level of inpatient hospital experience similar to the APRN transition of care policy that requires 2,400 hours and 24 months of practice after initial licensure.
So I'm just sorry to say one more thing, but I'm going back to Rachel's point of gatekeeping. Instead of saying away from physicians, could we say to APRNs or PAs or less qualified medical providers?
Advanced
We
practice
probably can't
providers.
say that.
Yeah.
Would that include PAs?
Yeah. APPs covers the whole umbrella.
Overall, the board was opposed to transitioning attending coverage for inpatients to advanced practice providers. We want to say away from physicians or just keep that the way it is?
I wouldn't say away from
Okay.
physicians.
Is it worth mentioning teams away from, opposed to transitioning to APPs not working as part of a team or something like that?
That's a good point.
You know, a team including a physician or something along those lines.
Overall, the board was opposed to transitioning attending coverage for inpatients to advanced practice providers. We have significant concerns about practitioners with less training and experience and the potential safety and quality ramifications. The board did fully support the team approach of care that includes physicians. If this bill were to proceed, we would recommend treating PAs and APRNs similarly. We would also recommend a minimum level of inpatient hospital experience similar to the APRN transition of care policy that requires 2,400 hours and 24 months of practice after initial licensure.
How about supervised by rather than includes physicians?
I think that if we're trying to stress the team approach, that it might,
Yeah, I think team is in there.
yeah,
Team, I'm sorry, team including.
I hear what you're saying. I think I might leave it the way it is.
I'd move to approve.
Second. Any more discussion? Thank you. A lot of word crafting under pressure. I appreciate all of your help.
No, dull.
Well done.
Time for a break?
Yeah, I think we should take a quick break.
Yeah.
How many more?
S64 and S142 will be, I think, short, famous
Okay.
last words. And then few minutes on H588, which is an old issue, but a new bill.
Okay. Why don't we do this? Why don't we take a 10-minute break, then come back to executive session, because we need a little bit of time to switch over, do executive session, come back, and then finish the bills. Is that okay? So it is 2:15. How about we're back for 2:25? Okay, thank you.
And back to executive session, right?
Executive session,
You need
yes.
to move to go to executive session.
Oh, wait, I'm sorry, I'm sorry, you're right.
moved.
Second.
All those in favor?
Aye.
Thank you for reminding me, Margaret.
We heard you ask the question. It was just quick.
He's doing everything. He was on screen earlier.
Cleared with cache, I tried Chrome.
Mysteries of tech. Well, you're welcome to just give me the sign if you need anything.
We'll get there.
from the legislature's Website.
No.
Almost over.
Computer that would just type random special characters for a while.
She's climbing, she's on two. You're a specialist.
Yeah, it was the worst ticket.
Yeah. Didn't quite make any. And so I got a text.
Glad I got
from my work that needs to go to the hospital, needs stitches.
Fully dedicated to rock
Jay.
at this point.